After my last video on the Cannoli incident, several people asked me to explore the legal avenues that Awais, the manager, has to pursue a case against his employers on this workplace harassment. Having done a few cases on the workplace harassment myself, I jumped into my old notes and voila, what did I find? I found a very interesting and astonishing thing in the laws of Pakistan. What was that thing? You need to stay with me throughout the video. Pakistan introduced its first Workplace Harassment Act in 2010 under the UN and ILO conventions on the same. In 2010 and afterwards, there was massive statutory development on this area, as you can see over here. Actually, in 2011, we got recognition from UN. In 2012, different organizations also implemented that act within their own statutory provisions. However, following from 2013 onwards, there were certain lacunas and the act was not effective as it was hoped to be. Now, coming to the interesting and surprising part. The name of the act is Protection Against Harassment of Women at the Workplace Act 2010. And if you look at the preamble, it says the Constitution of the Islamic Republic of Pakistan recognizes the fundamental rights of its citizens to dignity of person, and whereas it is expedient to make provision in the protection of women from harassment at the workplace. So, what about the men working at the workplace? There is absolutely no law about men working in the workplace in 2010. I'm sure somebody within the legal lawmaking community must have realized what a blunder they've made. Hence, in 2014, an amendment was made wherein the protection against harassment of women at the workplace, the women was omitted and it was made gender neutral. And throughout the act, where women was used, it was substituted by the word persons, which meant man and women. Hence, everything was back to gender neutrality. And this was at least good as it covered both segments of a society and both segments of the working class. And again, in the Act, the definition of harassment was very narrow and was only related to sexual advance or sexual favors and natures, things revolving around that. However, in 2014, it was expanded a bit to produce improper conduct by an employer that is directed at and is offensive to employee or makes the employee feels to be working in a hostile environment, or objectionable act, comment, or display that demeans, belittles, causes personal humiliation or embarrassment, and any act of intimidation or threat. I know what you're thinking. This added definition is exactly what happened in the Cannoli incident. So, this is something we can actually explore. So, what is the procedure? It's all there in the Act. The power is given to organizations that they have to make and act on it. And if you're not happy with those decisions, you can always appeal to the federal ombudsman, the provincial ombudsman, and your governor if an ombudsman is not present. How effective is that? That's another question. As per the recent survey, about 80% of the organizations don't have this code of conduct incorporated within them. Some banks do because State Bank has this requirement, so the banks have to do it. But other than that, other organizations really don't follow this. There should be some law by the regulatory authorities that this should be incorporated within them. and it should be made mandatory. Other than that, we have 4 provincial ombudsmen who are supposed to be working on these applications or these complaints. However, as of 2018, there was only one ombudsman appointed that was in the province of Sindh. In Punjab, KPK, and Balochistan, we didn't even have an ombudsman. So I don't know where it went. And as for Sindh, in up till 2019, 438 applications were forwarded, and of them, 38 were decided. That's it. But the worst part is that this act gives power to the organizations to act. Hence, it is based on organization. The penalties are also organization based. They go from demotion, lack of promotion, to termination of employment. In this case, where he has been harassed by the owners of a company, I don't think he can apply, or the maximum penalty he can get is termination of employment, but they own the business. So, uh, where are they going to get terminated from? So, this act, or the only piece of legislation on the workplace harassment in Pakistan right now, may not actually work for Awais, the manager. So what do we do with Awais? Well, वो वकील के पास आया, ऐसे तो हम जाना ही देंगे, हम कोई ना कोई तरीका तो निकालेंगे. So हम क्या तरीका निकालेंगे? We need to get out of this organizational ambit. So what do? We open our beloved PPC, the Pakistan Penal Code. And if you look at section 509 of the Pakistan Penal Code, which discusses about the insulting modesty or causing sexual harassment, which was there before this workplace harassment act was brought in. This is the Mashhoor Act under which the Misha Shafi and Ali Zafar case was also filed. We can explore that, but there was no sexual harassment in this case. Hence, we can also look at section 504. Intentional insult with intent to provoke breach of peace, and it has all the explanation down there, and with the punishment of about 2 years. This is something we can explore, but I don't think it's going to be very strong for Awais. While we can explore a few weak options, but when it comes to a strong, rock solid case, I'm sorry, Awais, Pakistani legal system has failed you. This is my legal opinion on the issue. If you think differently or have different options that I have not considered, feel free to contact me or write below in the comments and let me know and educate me. Don't forget to subscribe. See you in the next video. Till then, bye bye.